I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on?
051 People versus Julio Soto. Entries of appearance, please.
Rafe Taylor on behalf of the people.
Good morning, Mr. Soto.
Morning.
We're scheduled this morning for appearance on bond. I believe this is Mr. Soto's first appearance before the court. Mr. Taylor.
Your Honor, I have a Rule 5 advisement and mandatory protection order. The defendant was unwilling to sign. If I may approach.
Yes, please. Thank you. All right, Mr. Soto, we're going to talk about a couple of these documents that we need to address for your first appearance this morning. I'll note for the record, Mr. Soto does appear out of custody and pro se, having posted an appearance bond on May 22nd. Mr. Soto, the first of these documents we need to address is this Rule 5 advisement under Rule 5C2. Did you have an opportunity to review this advisement?
I did.
All right. And do you understand each of the bulleted paragraphs on this page? All right. Well, I'm going to go ahead and explain them to you then. So the following is an advisement of your rights. Please listen carefully as these rights will pertain to you and your case. You have the right to remain silent and you do not need to say anything to anyone about the facts of your case. Any statement that you do make can and may be used against you unless it is something that you say to your own lawyer or a statement made to the district attorney while attempting to negotiate a plea agreement. You have a right to be represented by an attorney. If you cannot afford an attorney and you are considered indigent based on state guidelines, you may request that an attorney be appointed to represent you. If the public defender is appointed to represent you while you are in custody, which is obviously not the case here, then you are released from custody. You must then travel to the public defender's office and reapply if you wish to continue to have such representation. The district attorney represents the state of Colorado and does not represent you. The district attorney cannot give you legal advice. In most cases, you have the right to have a reasonable bail set. We may discuss bail today when your case is called. If you are a defendant on a victim's Bill of Rights case and bond has already been set by schedule or on a warrant, the bail cannot be discussed until the court can find compliance with the victim's Bill of Rights. If this applies to you, then your case would be set over expeditiously on the issue of bond to allow for compliance. You have the right to a speedy and public jury trial, or if the district attorney agrees, a trial to the court. You are presumed innocent, and if you plead not guilty, you have the right to require the district attorney to prove your guilt beyond a reasonable doubt. At trial, you have the right to cross-examine witnesses, the right to testify on your own behalf, the right to subpoena witnesses to testify on your behalf, and the right to appeal any rulings or decisions in the event of a conviction. If you are charged with a petty offense, you are entitled to a jury trial if, within 21 days after entry of a plea of not guilty, you make a request to the court for a jury trial in writing and tender to the court a jury fee of $25 unless the fee is waived by the judge because you are indigent. In petty offenses, you have a right to a jury of 3 unless a greater number not to exceed 6 is requested by you in the written jury demand. If you are alleged to have violated any law pursuant to Title 18 of the Colorado Revised Statutes, the law requires a mandatory protection order will enter against you. This protection order will state that you will not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are charged with committing. And other conditions may also be ordered by the court as part of that protection order. Compliance with the mandatory protection order will be made a condition of any bond posted in your case. And if you fail to comply, your bond could be revoked or new charges could be filed against you, or contempt proceedings could result, or any combination of those events could occur. You may be able to resolve your case by plea agreement, but please keep in mind that any plea of guilty which you may enter may be, or rather must be, a voluntary plea and not the results of any threats, coercion, or undue influence on the part of anyone. Any agreements that you make with the district attorney must be in writing. After you have read these rights, you may have a conference with the district attorney to determine if you and the district attorney can reach an agreement regarding your case. This could be an opportunity for you to obtain more information about your case. You do not have to speak with the district attorney if you choose not to. And after you have been read this advisement, whether you choose to speak with the district attorney or not, your case will be called up by the court to either accept an agreement or set the matter for future court proceedings, such as motions, trial, appearance of counsel, or another setting. And so do you have any questions for me based on any of those advisements?
No, I don't.
Sir, have you ever served in the U.S. Armed Forces, or are you a veteran?
No.
I'm going to mark this form no. And I'm going to stamp this as reviewed with and acknowledged by Mr. Soto on the record today.
Hold on. Do you say if I have any questions?
Yeah.
So under the Sixth Amendment of the United States Constitution, it grants me the right to know the nature of the cause of the action you are bringing against me, and grants me the court to the duty to tell me. I don't understand the nature of the cause of this action which has been brought to me.
So you're asking what the nature of the proceeding is?
Yeah.
We're going to get to that in just a moment when we talk about the charges that have been filed against you. In terms of your rights, do you have any other questions about those rights that I just read?
Like I said, I don't understand
What don't you understand?
the nature of the charges that you bring
Yeah,
against.
we're going to discuss your charges in just a moment. But in terms of the advisement I just read to you, in terms of the rights we just discussed, do you have any questions about that?
No questions on that?
All right, I'm going to go ahead and stamp this as reviewed with and acknowledged by Mr. Soto on the record today. All right, the next order of business is the 4-count complaint and information. Sir, did you receive a copy of the 4-count complaint in this case? Has 4 charges on it?
I did.
Okay. And so you're asking about the nature of those charges? Is that the question?
Yeah.
Understood. So you're charged with 4 counts in this case. The top counts charged against you are, or the top count charged against you is a class 4 felony, assault in the 2nd degree. That particular offense carries a maximum penalty of between 2 and 8 years in the Department of Corrections, a maximum fine of $500,000 and 3 years of mandatory parole. And that count alleges that on or about November 16th of 2025, you, Mr. Soto, with intent to cause bodily injury to another person, unlawfully and feloniously caused bodily injury to Salvador Rodriguez Gonzalez by means of a deadly weapon, namely a firearm. And so that is count 1. And I misspoke. Count 1 is punishable by 5 to 16 years in the Department of Corrections with that same fine and a mandatory period of parole. Count 2 is conspiracy to commit assault in the 2nd degree. That is a class 5 felony, and it alleges that on or about November 16th of 2025, you, Mr. Soto, with the intent to promote or facilitate the commission of the crime of assault in the 2nd degree, unlawfully and feloniously agreed with Transito Soto that one or more of you would engage in conduct which constituted that crime or an attempt to commit that crime, or agreed to aid the other person or persons in the planning or commission or attempted commission of that crime, and an overt act in pursuance of the conspiracy was committed by one or more of you. So that's count 2. Count 3 is felony menacing. That's a class 5 felony. It alleges that on that same.
Now the pressure is building. Notice how the judge carefully listens to every statement instead of reacting emotionally. In court, confidence alone doesn't win cases, evidence and credibility do. Do you think the person testifying is telling the complete truth, or is something important still being left out?
On that same date, November 16th, 2025, you, Mr. Soto, by any threat or physical action, unlawfully, feloniously, and knowingly placed or attempted to place Salvador Rodriguez Gonzalez in fear of imminent serious bodily injury by use of a firearm. Finally, count 4 is conspiracy to commit menacing. That's a class 6 felony, and it alleges that on or about November 16th, 2025, you, Mr. Soto, with the intent to promote or facilitate the commission of the crime of menacing, unlawfully and feloniously agreed with Transito Soto that one or more of you would engage in conduct which constituted that crime or an attempt to commit that crime, or you agreed to aid the other person or persons in the planning or commission or attempted commission of that crime, and an overt act in pursuance of the conspiracy was committed by one or more of you. So those are the 4 counts charged against you. Do you have any additional questions with respect to the nature of those counts?
Is this going to be a civil or a criminal action?
This is a criminal case.
Criminal? So there's 2 criminal jurisdictions in this constitution. There's 3 jurisdictions. If it's a civil, you must immediately dismiss this case.
We're not going to dismiss the case today, sir. Do you have any other questions?
So I move forward to dismissal for reason is because you are in the wrong court. I'm in the wrong court. They can bring the same case against me by the same judge.
All right. If you believe there's some kind of defect with respect to jurisdiction, you're welcome to file a pleading. I don't perceive any defect this morning. You're charged with a crime that occurred or is alleged to have occurred in Arapahoe County. This is a criminal court in Arapahoe County, and so the court finds adequate jurisdiction. But if you believe there's a jurisdictional defect, you're welcome to file a pleading. Do you have any additional questions about the nature of those 4 counts that were charged against you?
Okay, for the record, let the court show that the action in this criminal action, the conspiracy against the court to criminal jurisdiction to dismiss this case.
To the extent you're moving to dismiss the case, that motion is denied. Do you have any questions about the 4 counts that I just described to you?
At this point, no.
Okay. This mandatory protection order will contain some things that you'll need to comply with as a condition of your bond. Do the people have any record or VRA record with respect to the protection order?
We do not, Your Honor. Thank you.
All right. And so, Mr. Soto, this order will name you as the restrained person. It will name Salvador Rodriguez Gonzalez as the protected person. The order does not involve a crime of domestic violence, but it does involve a Victims' Rights Act offense. And the order will contain the following terms. First, that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are accused of committing. Second, you will vacate the home of the victims and witnesses and stay away from any location they are likely to be found. And third, you will not contact or have direct or indirect communication with the victims or witnesses. Beyond that, you will not possess, purchase, or control a firearm, other weapon, or ammunition. And finally, you will be restrained from Scooters Sports Bar and Grill at 13698 East Alameda Avenue in Aurora, Colorado. Do you understand each of the terms of this order?
No, I don't.
What do you understand?
Like I said, I don't understand the.
I'm not asking you about anything on those papers, sir. I'm asking you about what you don't understand about the terms of this protection order I just read to you.
I don't understand the nature of the charges that you're bringing against me.
I just asked you a moment ago if you had any additional questions about the charges. We've now moved on to the protection order. Do you have any questions about the terms of the protection order?
I've seen a couple it's going to be under common law or.
No, this is statutory law that contains crimes that you are accused of committing. So this is a criminal case. It's based on a violation of statute. And those 4 counts that I just read to you are the counts that have been charged against you. With respect to the protection order and the terms that I just read to you, do you have any questions about those terms that you're required to comply with?
Is this right here under common law? I should have.
I just answered that question, sir. This arises under statutory law.
The injured party under the common law, whereas the default, there's an injured party. So there's no injured party.
Yes, there is. The injured party is the individual who I read to you, Salvador Rodriguez Gonzalez. That is the alleged injured party.
I don't see no injured party here, so there's no evidence at all.
Mr. Soto, if you would like to file a pleading with respect to whatever you've got on your papers in front of you, you're welcome to do so. I'm not going to hear any more argument as to that this morning. Do you have any questions about the mandatory protection order?
No, I need to read it again.
I'm not going to read it again. Do you have any questions about the order?
No.
You're going to be required to comply with this order. I'm stamping this as reviewed with, acknowledged by you on the record today. If you violate this order, you will be held in contempt of court, or you may be charged with a new crime, which could be a misdemeanor or a felony. All right. Mr. Soto, do you have a plan for an attorney in this case? Do you intend to apply for a public defender or hire private counsel?
No, I'm going to represent myself.
You're going to represent yourself. All right. Well, I'm going to provide you with the Arguello advisement, which is the advisement that must be provided to an individual when they have indicated that they wish to represent themselves in a case such as this. So, sir, you have a right to have a lawyer, but you must prove to the court that you're working hard to find a lawyer. In this case, you're saying that you don't want one. And you can work hard to show the court that you are trying to find a lawyer by applying to the Arapahoe County Public Defender's Office. If you qualify based on your income level, you've indicated that you do not wish to do that. The other option is by hiring a private lawyer to represent you. You have indicated that you don't wish to do that either. And so ultimately, the court will treat that as giving up your right to a lawyer this morning. You've indicated that you wish to proceed pro se and represent yourself. The Highest charged against you is a class 4 felony, second degree assault with a deadly weapon. I'm just going to fill out this form. I'll be back with you in just a moment. All right. As I mentioned previously, assault in the second degree with a deadly weapon is the top count charged against you. That's a class 4 felony. It carries a maximum sentence of 5 to 16 years in the Department of Corrections and a maximum fine of $500,000. And so I have a couple of questions for you. What was the last year of school or education you completed?
No comment on that.
What was the last year of school you completed, sir? Do you have any legal training?
Legal what?
Legal training?
Don't know that question.
That's a no?
I don't know that question.
Okay. I'll take that as a no. Do you understand that the criminal law is a complicated area and that having a lawyer trained in this field could be of great help in preparing and representing you in your defense? No.
Can you repeat it?
Do you understand that the criminal law is a complicated area and that having a lawyer trained in this field could be of great help in preparing and representing you in your defense?
Yeah, I don't need one.
Okay. I'm going to mark the form no. Finally, sir, you will go on to the next step of this case without a lawyer. You will take a serious risk that you will not present your case well, including risking your right to cross-examine witnesses and address those witnesses against you, risking your right to have someone testify for you, even if they do not want to by way of a subpoena. And
This is where the courtroom atmosphere completely changes. Small inconsistencies begin to stand out, and every word suddenly matters. The judge isn't just listening to what's being said, he's paying attention to what's missing as well. Moments like these often decide the entire outcome of a case.
and risking your right to remain silent since anything you say can be used against you. And so ultimately, with respect to your decision to represent yourself this morning, are you under the influence of any drug, alcohol, or medication that's affecting your decision?
No.
All right. Mr. Taylor, what I'm going to do is ask you to approach, and Mr. Soto, I'm going to have you sign this document that you have decided to proceed pro se. Your Honor, if I may approach? Yes, please. Thank you. All right. And apart from setting this matter for preliminary hearing, are there any other issues from the people this morning?
No, Your Honor. Thank you.
All right. Let's go ahead and set for a preliminary hearing from the people. Are there any dates you'd like to propose? All right. June 25th, 1:30 p.m. for a preliminary hearing. Mr. Soto, we will print you off a setting slip that'll have that next hearing date on it, June 25th at 1:30 p.m. And we will see you back here then. Your bond will be continued through the preliminary hearing date. Have a good day, sir.
As well.
Ready on Mr. Madrid's case?
Good morning. We are on the record in the matter of People versus Latavis, Trishad Thornton. This is case 25-0203-FY. May I have appearances for the record, please? Mr. Anid?
George, thank you, Anna. George Anid for the people.
Thank you. And Mr. Thornton, could you state your name for the record, please?
I am Shoulders in here by way of Executive Office for Latavius Trishad Thornton, nonprofit organization.
Accept that as Mr. Thornton announcing his appearance before the court. We are here this morning for a pre-exam conference. Mr. Anid, it is my understanding that Mr. Thornton has declined representation. However, Mr. Thornton, at every appearance, I need to remind you that you have a constitutional right to be represented by an attorney, and that if you can't afford an attorney, the court will provide one for you. I am particularly proud of the superb public defenders we have in this court. However, you may also retain any attorney you wish. You will get to choose the attorney. You would have to pay them. You have a constitutional right to represent yourself, but I have to warn you that if you proceed representing yourself, you would be held to the same standard as all attorneys who have gone to law school, passed the bar, and been admitted to practice. So the court really can't give you any breaks or help you at all. Is it your wish to represent yourself, sir?
Mr. Thornton is aware of the courtroom decorum and the standards and procedures that must be upheld by a person in representation of a party. And as again, I shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before. And also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used. And to forgive me, and to uphold the proper standards. Mr. Thornton does not wish to get public counsel representation for, as I am a legal representation by special appearance through the executive office for Mr. Thornton and not the actual entity, Latavius J. Shaw Thornton. Once again, on the record, it has not been declined that Latavius J. Shaw Thornton is a nonprofit organization, which, yes, Your Honor, is a person, in fact. And I, the man speaking with a voice and
Okay,
a
so
sound
I'm gonna
mind.
cut this off. I don't want to mute you, but we have to move forward. So, we have an attorney standing by. That would be Mr. Foreman, who is a very, very good public defender who is available to you. At this point, Mr. Anid, this is the time and date set for a pre-exam conference. Have you had an opportunity to speak with Mr. Thornton about any plea offer?
No, Your Honor, and I don't think I'll have any meaningful conversations with him based on what I see. I believe that it's not clear whether what he's doing is intentional or whether this may be a competency issue. But I'm prepared to proceed. I just don't know if we should be. We should. I have a concern for his competency, to be honest with you. If the court, we had the same issue this time.
No, Mr. Thornton, one person at a time. And right now, Mr. Anid is speaking.
I mean, I guess I would inquire with whether he knows what a preliminary exam is, and if he understands, if we forward, if he's gonna know what to do. I mean, I believe I have to look at the court rules. I've never dealt with this issue, but I think having standby counsel would be something that would be needed to advise him. I'll look into all that, but I just don't know if he's gonna know what a preliminary exam is. I believe this may just be a competency issue. I don't know, Your Honor.
Okay, so actually that's a good question. So Mr. Thornton, I'm going to ask you, what is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir.
you?
No, we're gonna focus our answers here. What is a preliminary exam?
Your Honor.
I'm going to give you
Your
one
Honor.
chance to answer. What is a preliminary exam?
A court proceeding.
Okay, and what? Okay, and what happens? That's a good answer. What happens at that court proceeding?
At a preliminary examination court proceeding, the parties have the opportunity to present evidence, cross-examine each other, and determine whether whether evidence is admissible to go into continuing proceedings, whether the court has jurisdictions. A plethora of matters may be brought up in a preliminary examination to see if the court has a valid standing, to see if there's anything, to see what may be addressed that's necessary as far as the parties that are at hand, not only to go about things in one specific fashion.
Well, that's pretty that's a pretty good answer. However, at this point, given a review of
Your Honor,
history, the court is going to sua sponte suggest that a competency exam be ordered. Mr. Anid, any response?
I agree.
Okay, thank you. Mr.
Yeah.
Thornton, any response?
Mr. Thornton does not believe that a competency exam sua sponte is necessary and objects that as a preliminary exam is something that we can proceed to and we can address the matters and the situations that are necessary at that time. And for the sake of due process and the judicial precedence of due process, that a criminal a competency test may delay that, and it could hinder not only Mr. Thornton, but the things that Mr. Thornton does as far as the community and his career and his family and his life and rights, and other people that may be affected by this matter, as well as the public. Because for the judicial precedence is that Mr. Thornton is innocent and not guilty.
So, Mr. Anid, are you going to prepare a proposed order or?
Your Honor, I think it's been a while since I've done. I believe if I'm not mistaken, it's the. I can if you want. Yes, I'll prepare an order.
All right, so at this time, Mr. Anid, comments on the preliminary exam?
Nope. I just say we just make the preliminary examination to be determined date. If anything, reset it for another PCC or review hearing for when we do come back with a competency opinion.
Okay, so Mr. Thornton, you have two rights at play here. One is the preliminary exam that we just discussed, and the second is the right to have that within 21 days. So the reason that you have a right to have that within 21 days is to prevent cases from dragging on endlessly. There are certain timelines that have to be met. However, the court can waive that 21 days if it finds good cause. And that would be, for instance, if one side had recently received discovery and was unable to proceed. Another good cause could be if someone was ill or hospitalized. There could be any number of good reasons. So I'm going to ask you, actually, Mr. Thornton, have you received any discovery in this matter?
I have not. Mr.
Okay,
Thornton
so
has not received
because-
any instrument.
Okay, so
The tension is at its highest point now. Both sides have presented their arguments, but only one version of events can hold up under legal scrutiny. The judge stays focused on the facts rather than emotions, reminding everyone that the courtroom is about proof, not opinions. Which side do you think made the stronger case?
So, all right, two things then. First, I find good cause to waive the 21-day rule, and we will get
Objection, Your
a
Honor.
date. No, sir, just a minute. Let me finish.
All right.
You can't, you don't, no, I don't want to mute you, but I have to get through this. So, you have to have, you have a constitutional right to have knowledge about your case. And if you haven't received any discovery, we can't go forward until you receive it. So two things. First, I'm going to waive the 21-day rule. And just a minute, Mr. Sid. We're going to waive the 21-day rule, and we're going to set a date out in about a month. That'd be a placeholder date. As soon as we get that date, then we'll go to the discovery issue. So next up, where we're going to adjourn this case just to turn it. We're going to adjourn this case to I just lost that chat. To a probable cause conference at 8:30 a.m. on April 25th. And a preliminary exam date of 9 a.m. May 1st. Now, Mr. Anid, you wanted to be in a breakout room with Mr. Foreman. I'm guessing you want to discuss discovery. So.
And you, Judge.
With me, or you want to discuss me?
All three of us really quickly. That's okay.
Okay.
I will like.
Do that? Okay. Just a moment, Mr. Thornton. We'll be back in just a moment. Okay. Thank you. All right, we are back on the record in the matter of People versus Latavis, Trishad Thornton. This is case 25-0203-FY. And for a moment, at Mr. Anid's request, the court, Mr. Foreman and Mr. Anid discussed standby counsel. So standby counsel is something with certain mechanical concerns. So for standby counsel, the court can't just appoint standby counsel. This is what we discussed in the breakout room. The court, or perhaps its funding unit, the city of East Lansing, would have to enter into a contract with the public defender's office. And if both sides agreed to that and a certain financial rate, then an attorney from the public defender's office would sit next to Mr. Thornton and be available to advise him during all proceedings. Back in the day, when I was on the court appointed list, a judge could just appoint someone and do it. That doesn't exist anymore because of the MIDC. So we discussed the mechanics of that. The court is going to make a formal discovery request on behalf of Mr. Thornton. So Mr. Thornton, you should receive at the jail, or if you post bond, at the address we have on record, all of the materials that a defense attorney would receive that the prosecutor has. At this point, Mr. Enid would like to speak with Mr. Thornton and perhaps see if a plea deal is possible. So Mr. Thornton, you never have to accept a plea deal, but it's worth listening for two reasons. First, there may be something there that you can reach an agreement on. You have a constitutional right to have these charges heard at a trial. Sometimes you can make a bargain, something that is worth giving up your right for a trial, for instance, a lesser charge, a lighter sentence, or both. The other side is you kind of want to know what the prosecutor's thinking about the case. So, as a defense attorney, I always wanted to hear what the plea offer was. Even if my client was absolutely not going to take it, it gave me some insight into where the prosecutor was interested in going with the case. Again, you were never required to accept a plea bargain. At this point, because you are representing yourself, I'm going to allow you to converse with Mr. Enid, recognizing that you do not have discovery materials, so I do not expect this court to accept a plea bargain today. All right. We're going to put you both in a breakout room, and when you're done, the court will be ready. Thank you. Okay, sound is back on at the jail, so we will go back on the record in the matter of People versus Latavius Rashad Thornton. This is case 25-0203-FY. Mr. Enid, prosecutor, and Mr. Thornton, representing himself, have met in a breakout room. So first, because the prosecutor has burden of proof, I'm going to ask Mr. Enid first, then Mr. Thornton, I'll ask you. So Mr. Enid, anything from the breakout room that you'd like to report?
Yes, I just want to make sure Mr. Thornton is there because I don't see him on here.
Oh, I see him. Do you?
Okay. Can you hear me? Okay. Yep. So we discussed. Yep. We discussed a little bit of as much as we could. I believe based on my discussions with him, I don't believe this is a competency issue. I believe this is more of the what Mr. Thornton kind of described earlier. So the plan, I think we both agreed on, is we're asking for another probable cause conference. I'm going to somehow figure out how to provide him discovery, the complaint, the information, all the charging documents that we have. We're going to come back. In the meantime, I'm going to do my due diligence to speak with our office to see how we're going to go forward with this. Because I know it's my understanding he wants to represent himself. That is his right. I believe based on the questions that you asked earlier, he answered them pretty fairly, Your Honor. I just want to make sure we got all ducks in order. I discussed a misdemeanor offer potentially with them, but also discussed that I encourage him to get a public defender. All these things I think we're going to discuss at the next probable cause conference. I think these are all appropriate matters so I can get my ducks in order. He can have discovery to know what he's looking at. And I believe at the next hearing, we will have a good understanding of what we're doing going forward.
Mr. Thornton, is that an accurate report?
It's pretty accurate, Your Honor. Just a few more points that we had discussed in that breakout room was also that it was in the discovery we would like to get subject matter in the appointment of the authorities that has been filed onto the record for these proceedings and how we came about to be into the court's jurisdiction for this matter in such fashion. And I think that's kind of what
that's a word salad. It's not making any soup. Can you make sense at all? Can you rephrase that for me? Mr. Thornton.
Okay. So just pretty much all in the discovery, we didn't want any documents that have been filed onto the case to be missing. And that's what I mean by not limited to the documents titles that he named. It include an inclusion of all documents filed with all titles under them.
And
okay.
I'll
yes,
chime
Mr.
in.
Ned.
And I think kind of what he may be talking about is, and I could be wrong, is the charging documents, what gives us the authority to proceed forward and how we're proceeding forward. And I explained you should wait until you discovery because I believe that's going to be the complaint, the information, and the other charging documents to see where we're at. I could be wrong, but once he receives those, we'll come back. We'll have all the ducks in order. I think that's a good resolution we both agreed on. And in the meantime, I'll do my due diligence to speak with our officer how we're going to go forward. I told Mr. Thorne, I'm the prosecutor. He understands what the prosecutor is. I'm not on his side, but I did advise I'm here to help get the situation resolved as fast as possible. And I think we both agree that if you find good cause to adjourn this for one more probable cause conference, I believe everything will be situated. The only thing I have to ask is how do I provide discovery to Mr. Thornton?
I would guess that you could mail it to him or, yeah, I think.
I'll figure it out. I'll ask my office.
Communication through the jail.
Okay.
At his address through the jail, and it may have to be paper communication.
Okay. I'll do my due diligence today when I go back, when I get to the office today, Your Honor.
Okay. And yeah, I don't have discovery demand in front of me, but that would include, of course, any exculpatory materials granted under Brady. That would include make a request for any body worn camera, any evidence you plan to introduce, any car video, any report that you have in your office other than what's protected under attorney-client privilege with the prosecutor or any counsel. Mr. Thornton, anything further this morning?
Not at this time, Your Honor.
Just new dates, Your Honor. New dates, new probable cause.
Okay, so we had the dates, and that is 8:30 a.m., April 25th, for a probable cause conference, and 9 a.m., May 1st, for a preliminary exam.
Okay, so the next probable cause conference is about a month away. Does that sound right?
Yes.
Okay. All right.
So, Mr. Thornton, if at any time you change your mind, you can communicate with the court and or Mr. Anid about requesting counsel. At every hearing, I'm obligated to tell you your right about counsel and to determine the parameters of that. All right, so we will see you back at 8:30 a.m., April 25th. That is all.
Thank you, Your Honor.
Thank you.
Take care.
Thank you.
Take care, Mr. Amid.
After hearing all the testimony and reviewing the evidence, the court reaches its final decision. This case is another reminder that honesty, preparation, and solid evidence carry far more weight than emotional arguments. Every courtroom battle teaches an important lesson about accountability and justice.